One
Hi,
syllable.
everybody. I'm honored, as always, to have the erudite, affable, eloquent, knowledgeable attorney with me, Ron Coleman, and pronounceable Ron Coleman.
How are you? Good to see you.
Excellent, thank you.
What's on your mind, Randy?
I would like to be educated in general, but specifically from you today on the recent June of the Supreme Court. It's not only Pride Month; it actually happens to be Supreme Court Month, I guess.
Well, it's been a pretty wild ride. We had a few really important decisions. Some of them were disappointments, but more of them were good for America, good for people who see the world the way we do, than the other way. I'll start with the bad news first. The Murphy case, the Missouri social media censorship case, was thrown out after an original grant of certiorari this was the case that was brought by a number of plaintiffs, including state attorneys general, complaining about the federal government's infiltration and direction of censorship activity at major social media platforms, all of which it is undeniable happened. The Supreme Court ruled on an appeal from a preliminary injunction that had been affirmed by the Fifth Circuit. This was a preliminary injunction prohibiting such activity in the future. The Supreme Court ruled that injunction was improperly granted because the plaintiffs lacked standing. And I'm not utterly surprised. I mean, there was something of a standing issue there in terms of demonstrating, or at least pleading, actual damage to the actual plaintiffs involved. It's a super important case. The Supreme Court could have avoided the standing problem by granting certiorari in another case that it had been holding in abeyance during that time, which is a case that my firm, including myself, have been very busy with over the last couple of years, which is O'Handley, an appeal from the Ninth Circuit, where our client had smoking gun proof of his actually having been deprived of his platform on Twitter as a result of instructions from the California Attorney General to Twitter. And without comment, they, the day after, they vacated the injunction to Murphy and sent it back down. Maybe they didn't even send it back down. I think they found that there was no standing. We were hoping that maybe they would look at our case because there really is standing, and they just denied it. And when the Supreme Court denies certiorari, they don't have to explain their reasons. So that's disappointing, especially going into election season. I do think that the process of litigating these cases and raising their profile has nonetheless been very valuable. People are now absolutely aware of what has been going on, and the fact that Twitter is no longer owned by the same company that cooperated so, whether it was willingly or not, it was almost perfectly, well over 95% compliance with the government's instructions. The fact that Twitter is no longer that platform helps. It helps, and the fact that we know more about what happened helps. I can't really say the Supreme Court made a mistake, so I just don't know if the standing argument is right or wrong. It's a really esoteric area of law. I've heard people who are more familiar with that area of law say that they were wrong. It's a shame. It's a shame that they couldn't consider it because it is a really, really important issue. So that was the most bad case. There were some very good cases, though. One of them, well, the most obvious one, I mean, why should I don't have to be like the Supreme Court and be coy and not only wait until the end of the schedule, but add another day to the schedule, as they did with the Trump immunity ruling, which was really not a surprise to anyone who has any familiarity with the topic. And when I say any familiarity, I mean like my level of familiarity, which is glancing indeed. People on the left who were taking bets on, how this would be, how the DC circuit would be affirmed. It was not because of a lack of familiarity with the law. It's because of a level of psychological, I guess it would cognitive dissonance. I mean, they're simply not thinking about issues anymore. It's a religious exercise that they're engaged in.
I completely agree.
Yeah, I mean, the fact that people who hold themselves out as, and at one time could be reckoned to be serious constitutional scholars, are able to say, oh yeah, it makes perfect sense that every judge, every prosecutor, every member of the executive branch, except the president, except the sovereign, is entitled to sovereign immunity. That makes sense to them is insane. You don't have to get any more esoteric than that. It's insane. Especially because all the official activities for which immunity, the Supreme Court exists, some of them are core constitutional powers, like running the military, but others of them are powers that have been granted by the burgeoning administrative state. If Congress doesn't want the president to have powers in those areas, then it should stop giving the president power. They should stop giving the state power. They have a lot of trouble with that. Another important point, though, that came out of that decision, I wouldn't have minded if it had been a little bit more pungent, was the fact that the court commented not once but twice on the fact that, notwithstanding how important these issues are, and including whether or not the acts in the indictment constitute official acts or non-official acts, which would always be the inquiry you would undertake in an immunity setting, those issues weren't briefed because the district court basically just blew it off. There's no immunity. F that. There was no oral argument. No evidence was taken. And the DC Circuit, which sees its entire job as being a political organ of the left, said, yeah, that's cool. The Supreme Court said on an issue like this, with the implications that this has, the fact that we're operating in an area of law where there's never been a Supreme Court opinion before, how do you not take evidence on this? So that one was remanded back to the district court for further proceedings, and that is going to be another horror show because the judge there is manifestly hostile to Donald Trump, and the fact that she did such a poor job of it once suggests that she'll do a very poor job of it again. An interesting side benefit for Trump from this opinion, which isn't all good for him, by the way. There are gradations of acts. There are gradations of immunity that he may have to be concerned about. Not that he is guilty of what he's been accused of, and not that what he's been accused of is necessarily even properly deemed a crime, such as commenting on January 6th about what people should do. I mean, it's so asinine. But because in the New York criminal travesty, the illegal acts complained of include ones that were definitely official acts by Trump, and that under the Supreme Court's decision would definitely be protected by immunity. Even the highly incompetent, and I'm giving him the benefit of the doubt by saying that, Supreme Court Justice who is presiding over the Trump criminal matter in New York Supreme Court, which listeners all know, in New York, that's what they call the highest trial court, but it's not the highest court in the state. It's the Supreme Court. Most other states that have that kind of nomenclature use the term superior court, okay, but that's not what they did in New York. In any event, even he had to acknowledge that he postponed sentencing because it's not clear to him what the decision does to the convictions, and he invited further briefing from the parties on that topic. Those are the first two. What else happened? Chevron deference was defeated. What was Chevron deference? Chevron is the name of an oil company. The case did not mean whatever an oil company says you have to do. Oh no, quite to the contrary. Mm-hmm. Chevron had sued the Environmental Protection Agency on the question of to what extent did that agency have authority to issue certain regulations. And in the case that came to be known as Chevron, because it was Chevron versus EPA, the court held, back when you and I were younger men, well, we hire these people to be the experts, and they understand those sciencey things, and Congress just wants to do good. So Congress gave them a do-good stick, and they know how to use the stick. So we defer to an agency's own determination of the limits of its jurisdiction and powers. What that meant is that not only would that statement that I just made inevitably result in a growth. What agency has ever said, "Oh no, we don't have"? I mean, they might say we don't have some subject matter jurisdiction over something in order to avoid doing some work, or in order to avoid solving some problem. But agencies exist to expand their power. Yep. I mean, that's not why they exist, but that becomes the raison d'etre for their existence. If you're a bureaucrat there, the more things you can be in charge of, the more important you are, the more valuable you are in the private market after you leave government. Just all the things, and the more budget you can get from Congress. So after experimenting with our lives for a generation, the Supreme Court, now made up of entirely different personnel, says, no, Congress, that was a mistake. Congress has to write the laws in a way that makes it clear what can and cannot be regulated and what each agency has the authority to regulate. And if there's a question, you don't go to the authority, you go to us. The left had multiple cows over this. Unelected judges are going to unelected bureaucrats was fine with them, even though the vast majority of them, unlike Article 3 judges, don't have to ever be approved by, confirmed by the Senate. And after all, what those judges said was, if we as professional statute readers can figure out what's being disputed, then we will. But if we can't, if we say Congress was unclear here, that means you go back to Congress, the elected people, which was never the case when the agencies decided themselves. They never said go back to Congress. Yeah. They would make, not only that, and this is a really huge thing in the securities area, these agencies would and do and still continue to have their own in-house judicial systems, where they would, since the Supreme Court told them in the Chevron case, well, you guys, we don't need judges. You guys are the judges for this. So they have all these administrative bodies that make these decisions, but it's by and for the agency itself. So that really became, an unaccountable and what we now see as unconstitutional enterprise. So that we're done with that's it for Chevron.
Thank goodness.
Yes, yeah, it's a good thing. And as a friend of mine, a new friend of mine from the world of internet law, very, very astutely pointed out, what you're not hearing from the press is that this is a gigantic threat to NGOs, because these bodies that would enter into settlements with regulated industries had the power to, and did, steer money from settlements to left-wing NGOs that were affiliated with, that were sort of parallel to the agencies, which funds a lot of this
lawfare.
Lawfare and activist litigation of all kinds.
That's kind of a regulatory capture cycle.
Absolutely. And this really does break that regulatory capture path to some extent. So that was a huge decision. Another huge decision was the use by the government, was the Supreme Court ruled that the government in the Fisher case could not continue to use a statute that was passed after to close a loophole that became apparent in the Enron scandal about the destruction of evidence as a way of prosecuting January 6th protesters or rioters. You can call them whatever you want. Whatever they weren't evidence destroyers. What happened during Enron was it became very clear, it was undisputed, that the people at, I think it was Arthur Andersen, forgive me if it wasn't, I'm pretty sure it was, the Enron's accountants were engaged in the process of shredding. Was it thousands? Was it hundreds of thousands? Lots and lots and lots of documents back before the digitized
Did they
world.
use bleach?
They used a cloth, and they shredded all these documents, and it was a felony to cause someone to destroy documents, but actually destroying documents yourself was not a felony, just something that was overlooked in the drafting of the statute. So that Congress came along and said, okay, anyone who by his own conduct interferes with the administration of justice or an official proceeding, yada, 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 that becomes a felony. So the January 6th prosecutors said, oh, well, the people who protested or rioted or insurrected outside the Capitol were trying to prevent the counting, the approval by Congress of the electoral votes, and therefore we see here that this falls under that statute. To which the Supreme Court said, no, that's not what we see here. That's not what the statute says. It's not consistent with the legislative purpose of the statute, and what the Justice Department the position they're taking is along the lines of, these votes are written on paper. These votes are documented, and the January 6th rioters had an intent to destroy the documentation. I mean, again, I've heard about it. I haven't read it in detail. Now, along the lines of Chevron, I mentioned in-house tribunals. That actually was addressed more directly in a case called SEC versus Jarkesy, which says that the SEC cannot use in-house proceedings to impose fines in securities fraud cases. That came up under the right to a jury trial, because what we found is that these proceedings amount in fines that are so substantial that they tend to be, they have the capacity to amount to a claim against the respondent that would, if it were brought in a court, entitle him to a jury. You're not entitled to a jury on a traffic ticket, but there is a money level where you are entitled to a jury. And I have litigated these cases. It's kind of amorphous. Building code violations in New York that can be imposed for actually plainly political reasons, like masking. They use the building code in New York to do stop work orders and to impose fines on construction sites for lack of adequate masking. purely political. I brought an Article 78 proceeding, as it's called in New York, to say that that was unconstitutional under New York law and under federal law. And of course, it was blown off. It was blown off by the Supreme Court of New York and by the First Department. That's how things go. So that was, I think, in terms of the biggest news of this June, of the last couple of weeks. That's the Supreme Court news.
Well, I appreciate that. It was interesting to me thinking about some of these administrative laws. I have some familiarity with a potential case going to the Supreme Court with the Mid-Cal standard, and that a bureaucracy has to follow two standards. This came out of North Carolina Board of Dental Examiners versus the FTC, I think. And the concept there is that for a regulatory board to have proper goodness, it needs to do two things. It needs to be either under statutory authority of the state with, and it has to show that, it has to show they're following the laws, and it has to have direct mandate to do whatever they're doing. They can't just out of the blue come up with rules of their own because they feel like it. It seems like some of these, the theme for some of these decisions is that there's a kind of cutback of what these freestanding, freeloading bureaucracies can do.
It is interesting to think that Mid-Cal would be affected by Chevron. Hopefully you get to find out soon.
Yeah. So that's under the Sherman Act. I'm wondering, if the Sherman Act could have been applied towards some of these Chevron I'm probably misusing this word, kind of peremptory decisions made by regulatory agencies.
I'm not sure I understand. You're saying
so far, the North Carolina Dental Board case was that the board decided against a company that was, I think, using ultrasound to clean your teeth or something like that. And they said, oh, you have to have dentists there. Like, well, we're not really touching your teeth. We're just doing stuff near your mouth.
And the Supreme Court said that if you're a market participant and you're a member, you're on that board, you don't get automatic immunity.
Right. You don't get automatic immunity because you have to be working under specific state directive. After the 2015 North Carolina decision, they could theoretically use Sherman Act aspects to show that they were acting on their own without direct authority of the state. So they were working, for whatever reason, meretriciously for whatever side interests and so forth, and as a cabal in a sense market participants. If they have an anti-Chevron attitude, which is not necessarily incredibly hard to believe, in the EPA, they hate oil companies and so forth. They're acting a certain way. They theoretically are market players, even if they're not oil companies.
Yeah, that's actually interesting. I think there are going to be some interesting cases that discuss how Chevron will affect those issues. Another aspect of it, to some extent, is these administrative bodies have their own sort of bodies of precedent, and they often disregard court precedent because they are their own little fiefs. That is probably upset to some extent by the Chevron decision, but where you're going on this, entirely too speculative.
I literally was cleaning out a swamp yesterday. We have a creek a block and a half away from us here, and a pretty large piece of a tree had fallen someplace and had swum down during a big rainfall, and it had wound up lodged in the creek, and it was kind of beaver damming the whole thing up. And And so I'm kind of that guy. I just put on big boots and I took a gas powered a little chainsaw, and I went in there so I wouldn't electrocute myself or whatever. But I cut the thing down to size. So I kind of drained. It wasn't really a swamp, but to the point, at various points my feet got stuck in the mud. It was hard draining this swamp because you get mired in it. It wasn't quite a swamp. It's really a backed up stream. But all the mud and everything, the muck, literally, it was a not quite Herculean, but it was interesting task. And I did it because it was 4th of July, and it seemed to have themes redolent of breaking things free and whatnot, and it was satisfying. But it's a tall task, and I don't know if you have any ideas on how. Let's say somebody came in who wanted to drain the swamp, how you do it, and whether some of the tools are laid out, or at least the ability is laid out within the last Supreme Court session.
Well, I mean, I do think that whatever it was that Vivek said there is certainly more elbow room to do it. Whatever it was he said, it's going to be easier to do after Chevron. It is going to be. I
apologize for bringing that on you. I could find it if I go in the background for a second, but carry on.
No, why should I carry on? If you want to find it, I'll
well, I'm gonna actually do that while I give you a topic and a question. I was reading this article by Mark Oshinsky, who's an attorney or an ex-attorney. I don't know if you stay attorney when you don't have your when you're not practicing, but he wound up unattorneyizing himself as a matter of principle. And this is a great article. I'm going to just show it here for my audience so they can find it. Don't count on courts to protect your rights. And he's really talking about the Murphy versus Missouri, which was originally Missouri versus Biden, which I actually think is a better title. But I know it kind of got like a football, or like a rugby ball kind of passed around.
We've been there.
But he talks about his own story that he did a pro bono case about sidewalks. That's what I think the nature of the original picture is here. Uneven sidewalks. I don't know if I can expand that enough. We actually have one outside our house. And the city in this case, made everybody cough up his own money, $3,000 to do that per person. And he went against the statute because it's kind of like an unfunded mandate, I guess. And I'm not going to spend a lot of time scrolling through this, but his point is that whatever this decision came out, and he was not happy with it per se, and understands the standing aspect. At some point, you have to kind of still take things in your own hands, kind of like me with that tree branch. You just have to go out and do things. You have to make your own Facebook. You have to make your own Twitter. You have to do Sami's dot. So the question would be, do we over rely on these Supreme Court decisions? Do we have to just go out and do stuff anyway? I mean, are we too passive sometimes and waiting for the courts to figure out our lives for us and to kind of say things one way or another? And I mean, let's say some of these decisions had gone the other way. What do we do? And are we kind of like I don't know, court cliffhangers? Are we?
Oh, well, there's no question. I mean, look, people are always coming to me and asking me what are the courts going to do about this? What can we as Ron, you're a litigator, can you solve this? Can you sue the government for how they did this policy and that policy? Well, remember what we started off with, the discussion of immunity. The government is immune. You couldn't govern if you weren't immune. If you could get sued every time you did some, you enacted some policy, no matter how disastrous. If that policy was bad, but it didn't actually deprive an identifiable person of constitutional rights, it's just bad policy, then you can't. The answer is no, you can't sue.
I'd actually kind of like to segue a little bit and talk about the last debate, the first debate, the only debate. I'm wondering what your thoughts are. Why the Biden team or his shadow government or his puppet masters picked June 27th, the earliest time ever for a presidential debate. I guess suppose in some sense it's maybe unique because both candidates had long settled their primaries. But was it kind of to bring up this point, to show the emperor's not new clothes, no clothes, but inability to really process and so forth, which was not a surprise for me at all. I mean, I've seen it going on for a long time.
No, not at all. I mean, look, the news here is that this debate made it acceptable to admit what everyone on the right has known all along, that the man is utterly unfit for office. The politics of that. I mean, look, one thing I don't subscribe to is this idea that it was engineered to happen so that they could get rid of him. It's a gigantic mess. Mm-hmm. If they had the power to engineer things like that, then they could have engineered him to slip in the shower. They could have engineered him to resign 6 months ago and find a real Democrat, a real candidate. But this idea that they would wait till this long, you say, oh, but Ron, they had the debate in June, and usually debates are later in the year. I don't really have a really good answer for that one. I have heard one theory which said that there is a party in Biden land that did want to force the issue because they felt that Jill Biden wouldn't let go unless it was really out front like this. But there's really no scenario, I think, where you can say that a party, an organization, a conspiracy is so powerful that they can orchestrate all this, but not do it in an immensely neater way. Because they've got multiple states, 3 or 4, depending on how you count them, where there's no way to get anyone but Joe Biden on the ballot.
Is that true?
Yeah.
So what if he happened to slip in the shower tomorrow? And
it's a good question. I don't know. I don't know the answer. I'm not an election law expert, and I was actually kind of trying to get some of the election law gurus from my firm to talk about this, and I missed, maybe because he represented the Trump campaign, they didn't want to give any free advice. But this is just it's a train wreck, and it undermines. Who wants to be that candidate now? It's not an enviable task, whoever it is. And also, I mean, what's their bench? Everyone agrees that Harris is awful, but not.
So in when Gerald Ford was president and he was unelected, he had Nelson Rockefeller take his vice presidential place, and whereupon for the election campaign in 1976 against Jimmy Carter, he chose Bob Dole to be his vice president at the nominating convention. And so, bye-bye Nelson. The Reaganish wing of the party, there were some thoughts about getting Reagan on the ticket. Anyway, they settled for Dole. They got rid of Rockefeller, which was the prime goal. So there's nothing really stopping. My own theory is that the transition, the slip in the shower, whatever, will be by getting Gavin Newsom to be the vice president. I mean, just get rid of Harris. She's obviously. I'm trying to think of some. I'll leave out whatever she is. I think people have a good sense of what she is,
and what she isn't.
Exactly. She has a sense of what the future can be, unburdened by what has been. And I think the whole Biden team would like to see what that ticket can be, unburdened by what has been Kamala Harris. And so I think that's really if I were a Dem, I would just make that look, Joe, fine. Okay, fine. You win. You stay on the ticket. I get it. But Harris has to go because she's like an incredible insurance policy for you. And we're going to put Gavin Newsom or somebody X on the ticket with you to run, just like Dole went with Ford. And that's that. And then all the Democrats are going to rest easy because Joe will have some sell-by date with the election, whatever. Maybe he just sits in the basement again, doesn't even run. Let's Gavin run the whole thing. And everyone, pretty much, understands that is the candidate. That's personally, I think that's their best and only solution, because that it takes away all the aspect of the electoral, which states have Biden's name and so forth. I think it's all done.
I think the only problem with that, and I think it's bubbled up a lot recently in the last couple of days, is that there's a really strong coalition. The Democrats are our coalition party, and the grievance coalition, the DEI, the minority coalition, is going to be super duper mad if you replace Harris with a white male. They will probably accept it if they replace her with a white female, and that's Hillary Clinton, because she's afforded some special status. I mean, that you have to admit it would be mind-boggling to have Clinton and Trump going at it again. But the fact that Harris is incompetent and unlikable is not considered to be a problem by these people. That's a feature, not a bug. They have staffed government and business with people who are incompetent and unlikable.
Have you heard the term kakistos? Oh, I can't even say it. Instead of aristocracy.
Yeah.
Aristocracy. There we go.
And thereby undermining the prospects and the reputation of the many minority people who are qualified and who are likable. But this is not a DEI affirmative action segment. But getting rid of Harris will draw blood as well. I mean, they sold her they turned a woman of Indian origin into a black woman. And, blacks in the Democratic Party, or at least a very large percentage of them, will apparently just buy whatever they're sold, just like Jews in the Democratic Party will. Trump is save Israel, vote for Trump. I mean, that's the world that these people live in. I mean, save Israel, vote for Biden. He's better for the Jewish state. People whose religion is the Democratic Party, blacks, Jews, abortion enthusiasts, alternative sexuality and fans. It's all about the power, but we grow fatigued. We're repeating ourselves.
Yeah. So the United Kingdom. Somebody posted that the UK for the first time has a practicing Jew as the prime minister. I don't know if you've heard this. I think they're maybe, I don't know if they're including or disincluding Benjamin Disraeli, but I think he converted along the way. But Keir Starmer apparently married a Jewish woman and does Shabbat and so forth.
Apparently. Terrible. It's a disaster. Terrible for the Jews. It's going to be a pro-migrant policy, which is also terrible for the Jews, but the non-Jews in the West will blame the Jews for the importation of more migrants who are hostile to, British culture and values and peace. It's just terrible. But that's how bad the Tory party is in the UK. They are consistently handed the opportunity to rule and consistently drop the ball.
Yeah, do you think it's like the Jeb Bush party or something? I mean, where do they go wrong?
I think that they make Jeb Bush look like Attila Hunt.
I think that I'm so disappointed in Boris Johnson. He folded. I think I clearly the press turned that scandal of Partygate. They're having parties during COVID and all that kind of stuff. It's hypocritical and all that kind of stuff, silly. He actually started out pretty good with COVID, and he was not going to follow the WHO mandates. He was not going to do lockdowns, all that kind of stuff. Then he got sick, and I don't know if maybe he borrowed RFK's brainworm, and something happened up there, and then he just turned all cowardly, and then he let this thing consume him rather than going after the press. I mean, it seems like if anybody on the left had done that thing, you would never have heard about it, and then it'd be like, he's doing so much good by locking everybody down. We can't let that get in the way. We overlook dementia, we overlook this, we overlook
Listen, I'm not really familiar with UK politics, but just in terms of the look of it, he came across like someone who his ambition had been to become prime minister, but the actual doing of the job didn't interest him that much.
Yeah. He's kind of, he has some talents. Like he can do, he can recite, Latin speeches he learned in what they call public school, Eton or something like that. He's pretty good at that. I heard him do a whole 10 or 15 minutes in Latin, and that was very impressive. But beyond that, yeah, it's kind of like Bill Weld actually could do that too. And so I think they're very similar, Bill Weld and Boris Johnson, not just the coloring, but kind of that aspect where they're squish and they're bright and they understood stuff. I think they paid attention during, high school and so forth. And
so there's room for those people to go very far in the Democratic Party, not to the very, very tippy top, but they get, that's the those are the technocrats who, become the agency heads and get cabinet positions and become, managing partners of the law firms that cluster around and protect and profit from the deep state. I mean, those people do very well. They get onto boards at Disney and stuff like that. I went to college with them.
So I'm going to segue slightly. We kind of focused on UK. I'm going to go slightly east still. And my wife recently got back from 2 weeks in Israel, and she was volunteering. I told everyone she had a plum job there. Literally, she was picking plums, amongst others. And it was actually difficult. They had to start very early in the morning because the heat was difficult. I'm wondering, what are your thoughts for the situation as is on the ground? How long is this kind of like, what is it, death by 1,000 cuts? In this case, missiles, drones, sword. I mean, it seems like endless from the north now. How does this all work out? I had a friend that lived in Metula, which is kind of like the northern finger heading towards into Lebanon. We in that town there were bunkers. When we visited in 2020, you could stare off into Lebanon, but I guess the town's still evacuated. I don't know if you hear any missives or thoughts. How does it? What's the next step there? How do things work? And then
you're asking the wrong guy. I retweet people who I find trustworthy, like the person who goes under the name Raylan Givens. I think he's a great follow on X. But I don't know this stuff.
Fair enough. Speaking of Raylan Givens, did you watch Justified?
No.
That's an Elmore Leonard character. I really love Elmore Leonard, the late Elmore Leonard, and Justified, the series came from him. It's well, I don't know if you indulge in that kind of stuff, but well worth a watch. So any final words from the sage attorney? Well,
I think it's worth, we do tend to be really pessimistic about things, and it's understandable why. But I do think that there's a lot to be said for patience and realizing that not every single institution has been hopelessly destroyed, and that these little fights need to continue happening, because what can you do? What can litigators do? And litigators really can't solve problem, and the courts are not going to solve our problem. But the fights that we can fight and that we do fight sometimes end up making a difference. And it's slow and it's frustrating just how little the courts that matter do what they ought to be doing. But marginally, every little victory adds a little bit more reason to be hopeful.
Yeah, I agree with that. I'm just going to go back to the Oshinsky article very briefly, because I think there's some things that are resonant with what you're saying, unless I'm misreading, of course. He goes, kind of after disappointment with the Murthy article, or the Murthy decision, he says, by coincidence, I read this passage, Psalm 127 this week. Unless the Lord builds the house, the builders labor in vain. Unless the Lord watches over the city, the guards stand in vain. In vain you rise early and stay up late, toiling for food to eat, for he grants sleep to those he loves. Children are heritage from the Lord, offspring are reward from him. Like arrows in the hands of a warrior are children born in one's youth. Blessed is the man whose quiver is full of them. They will not be put to shame when they contend with their opponents in court. I'm not sure, he says, I'm not sure how to interpret this. Does it mean ultimately God is in control, or that there's strength in numbers? Both can simultaneously be true. Regardless, and despite Murphy, opponents of chronomania and other government overreach can continue to resist and speak out. And every night we can lay our bodies down, sleep peacefully, knowing that we did the best we could to stop the madness when others said we were wrong. So that's not precisely what we have talked about today, but it's some interesting things. I think we always have to, keep fighting. We have to keep doing the best we can within the sphere and the tools we have, and realize that that's not the whole sphere. You still have to live well. You still have to be good to people. I find, even my congregation, there are some people who basically their pulse is tied to CNN. One very educated woman told me that literally, that she either sleeps or doesn't sleep based on kind of what Rachel Maddow has said and what her mood is. And it's kind of like, okay, well, fine, but I think you picked the wrong God. It's just...
yeah, right. But it really is something.
All right. So with that, we will end the day. And thank you, Ron. I appreciate it.
My pleasure.
All right. And
I hope I hope it's worthwhile.
It is. I learned so much from you, and I think you have a clarifying mindset and thought pattern. So I'm very much appreciated.
Thanks a lot.